Can I disclaim only part of an inheritance? Have you ever wondered if you can turn down just a piece of an inheritance? This is a common question that many people face when dealing with estate planning. The good news is that yes, you can disclaim only a portion of an inheritance. This is referred to as a partial disclaimer. As a beneficiary, you have the option to refuse a specific part of the property or asset you are set to inherit. This could be a certain percentage, a specific dollar amount, or even a particular interest within the inheritance. For instance, you might choose to disclaim a portion of an inherited individual retirement account or a fractional share of a trust asset while still accepting the rest. However, there are some important legal requirements to keep in mind. A qualified disclaimer must be in writing. It should clearly identify the deceased person and the property being disclaimed. You also need to specify how much you are disclaiming, whether it is a dollar amount or a percentage. This written disclaimer must be delivered to the person in charge of the estate or asset, such as an executor or trustee. In some cases, notarization or court approval may be necessary, depending on where you live. Timing is also critical. Generally, you must make your disclaimer within 9 months of the deceased person's death. If you are a minor, you have 9 months after turning 21 to make this decision. Another key point is that you cannot accept any benefits from the part of the inheritance you wish to disclaim. If you use or receive any benefits from that portion, it will invalidate your disclaimer. There is an exception for inherited individual retirement accounts, where you can receive the required minimum distribution for the year of death without it counting as acceptance. From a tax perspective, if you meet all the requirements, disclaiming a partial interest can be treated as if you never received it for gift, estate, or generation-skipping transfer tax purposes. You can disclaim all or a part of any separate interest in the property, even if you have other interests in the same property. In the context of elder law and estate planning, partial disclaimers can be a smart strategy for preserving assets and planning for taxes. For example, a surviving spouse might choose to disclaim a portion of trust assets that are not needed for living expenses. This allows those assets to pass directly to children or other beneficiaries, potentially reducing estate tax exposure. In summary, disclaiming only part of an inheritance is legally allowed and can be a strategic move in estate planning. Just remember to follow the legal formalities, keep an eye on timing, and understand the tax rules to ensure your disclaimer is valid and effective. Consulting with an elder law or estate planning attorney can help you navigate these requirements smoothly.